Let me first introduce myself. My name is Chris McCandless. I'm the new director over in the Office of Technology Management. And first day I got, Marsh and I got approached by Mark McGee saying, hey, we've been contacted by the USPTO. They'd love to have, as part of their university outreach program, they'd love to have a patent examiner come and visit and speak to your students and faculty. And I said, this is awesome. I'm all for this. Come on in. So I'd like to take this opportunity to introduce Mr. Asad Nawaz. He's a supervising examiner with the USPTO, that's the U.S. Patent and Trademark Office. And he's here today representing the USPTO Office of Innovation and Development's University Outreach Program. The objective of the Office of Innovation and Development is ensuring that inventors, small business entrepreneurs, university inventors, minority and underserved populations better understand, secure, and utilize intellectual property with the focus on patents. The University Outreach Program also includes providing presentations to university students, researchers, etc. on a variety of IP topics. Mr. Nawaz began his career in 2004 examining patent applications in the network communications area. In 2012, he became the supervising patent examiner of Art Unit 2468, which comprises of hybrid examiners examining multiple disciplines in addition to voice-over internet protocol and multiplexing technologies. He's also been a lead trainer for the labs in the Patent Training Academy at the Alexandria campus for the USPTO, and additionally was the lead trainer also? Lead trainer also for the inaugural class at the Rocky Mountain Regional Office in Denver. Mr. Nawaz's Bachelor of Science degree is in Engineering, Computer Science, and a Master of Science in Information Security and Assurance from George Mason University. Additionally, he's completed his we've talked about a little about this. He's completed his doctoral coursework in information technology with a focus in network security, and is conducting research in verifiable anonymity of mobile ad hoc networks. During his visit here at Mississippi State, he's also scheduled to not only eat with the engineering students, but he's also scheduled to meet with business students, discuss topics including overview of intellectual property and the patent process itself. And there's also an open seminar at the Mitchell Memorial Library Auditorium later today. That'll be at 2:30, from 2:30 to 4. So if you're available, please, there'll be a little bit additional information presented at the open seminar. So please, if you have availability, come and join us. And help me welcome Mr. Nawaz.
Very, very happy to be here. Since we have a little bit of a time crunch, because I like to talk a lot, we'll just get to it, okay? I'd like to keep this as open as possible. If you got a question, just blurt it out, okay? And we'll just address it on the spot. As Chris mentioned, I'm a supervisor in TC 2400, and specifically dealing with voice-over IP applications for the last 5 years. At one point, all the voice-over IP applications, which are Skype, Vonage, FaceTime, and all those type of things, all of those applications that were filed with the patent office were coming through my desk. As you can imagine, several thousand of them. So we started kind of dispersing those out a little bit the last year or so. So today I'm going to talk to you about intellectual property in general. So not just patents, but intellectual property. And why maybe you should get a patent and what exactly is patentable. So we'll talk about intellectual property and then kind of my strength of patents. A little bit about us. If you look right over there, that's my office right there. Okay, and this is the Alexandria headquarters where we have 8,600 examiners. That's a lot of examiners, but we do have a couple of satellite office locations in Detroit, Michigan, as Chris mentioned, in Denver, We'll be opening one up soon in Dallas, and we have one open out already in Silicon Valley, but that only judges are there. Soon there'll be examiners. We're expecting probably in October or so. The trademark side is much smaller than the patent side. And this, sometimes when I give this presentation, this is a slide where we kind of just stop, okay? Because there's so much information on it, and the next slides that come kind of just talk about each one of these aspects, okay? So if you got this slide down, I've way over exceeded what I wanted to accomplish today. Pretty much what you have here are different types of intellectual property. If you have an idea, how can you protect it? You have patents, and there's two types mainly, utility and design patents. You have trade secrets, copyrights, and trademarks. So instead of going through all of this stuff, all the information is up there, you can read it. Let's talk about maybe the intellectual property and suppose just the Coke bottle here, okay? The design, the ornamental design of that Coke bottle, that could be protected by and that is protected by a design patent. However, if you see the way the Coca-Cola is written over here, right? The typical design, the typical color scheme of it, that's branding. Every time you hear about branding, that falls into trademarks, okay? Copyrights would be any works that are written, what would be written about this? There's not much written about Coca-Cola. So, but it would be like if you write a book or a manual or something like that. The recipe for it, does anybody know about the recipe for it? It's a trade secret. It's one of the country's most famous trade secrets. Has anybody been to Atlanta? All right, did you guys go to the Coke factory? Yeah, did you see that vault in there? And then they tell you in the vault there's that secret recipe in there. Well, that's a trade secret. And the thing about a trade secret is you can keep it indefinitely until it's disclosed, okay? And there's legal ways of doing that and then illegal ways of getting it disclosed. So we'll kind of briefly discuss those. We talked about the design patent, right? But what about utility patents? That's the overwhelming majority of patents that are filed with the patent office, and those kind of deal with the actual functionality of something, okay? So it could be the bottling process or the machine that bottles the Coca-Cola inside the bottles. Does it make sense? All right. All right, before I go, I'm gonna ask you guys a question. You guys are all engineering students here, right? So give me another, say, trade secret. There's a very famous one. There's not many trade secrets many people know about. I'll go with any.
The secret recipe for Kentucky Fried Chicken.
Yes, the 7 herbs and spices, right? I would have taken SpongeBob's the Krabby Patty recipe too. Perhaps one of the most famous trade secrets is Google's PageRank algorithm, right? They've never disclosed the PageRank algorithm. Previously, whenever you went to a search engine, I guess like, anybody here heard of Alta Vista? All right, you guys are a little bit older. Okay, yeah. I thought I was dating myself here. Okay, so what those search engines did previously is they would put the relevancy of each web page along with the search hits. Search query with the search hits. They would rank those manually. There'd be somebody sitting there that would be ranking those. Okay, very tedious process. But Google came up with an algorithm of really ranking everything automatically, right? And with a great deal of accuracy. Two guys were PhD students, and then they decided, you know what, before we publish our work, we're gonna get out. So they never got their PhDs, and they kept it a trade secret, okay? So they rely on the fact that nobody else can kind of figure it out, right? So that's a big crux of the of trade secrets. All right, so who died and made you boss? The founding fathers, okay? The authority of granting patents and copyrights is actually in the Constitution. Article 1, Section 8, if you want to go specifically, Clause 8 as well, where we get the right to promote the progress of science and useful arts by securing for limited times It's a very big key. Limited times to authors and inventors the exclusive right to their respective writings and/or discoveries. And then the trademarks themselves that came from the trademark clause, the Commerce Clause, sorry. And then the federal statutes were enacted in 1870 and 1881. So this wouldn't be a university if I couldn't take an exam, right? So I'm going to take your exam a little bit. Everybody has a smartphone, right? So what we're going to do is we're going to figure out a way to kind of go through. I'm going to figure out how much information that you just absorbed from me, okay? Can somebody tell me some of the trademarks that we see on this device?
The logo.
The Apple logo, good, excellent. What else?
The term iPhone.
iPhone, good. All right. So anything that has to deal with branding, right? So it could be the name of the, yep.
The icons.
I'm sorry?
The icons.
The icons, but maybe not necessarily to Apple themselves. But yeah, that's branding, right? So when you see this specific App Store icon, you know that that's the App Store icon. Same thing with Safari, right? And it could be the name, it's also the names of those terms. Trademarks actually go much further beyond just maybe you know, like a logo or something like that. Trademarks can be color schemes, right? For example, Tiffany's. Right, so the lady in here. Do you know the color for Tiffany's? I'm sure you do. So does my wife. If it's even a little bit shade off, she will know. So it could be that. NBC, right? They have their peacock, that's trademark. Their three chime, right? Does anybody know the three-tone chime? Exactly, that's also trademark. So anytime we think about branding, we think about trademarks, all right? So pretty good on with that. All right, patents. What kind of patents are in there? And then we're going to try to stick with utility patents here. Go ahead.
Processor.
The processor, good. The chip that's in there, right? What else?
Maybe the home button.
Okay, the home button. The location of it, or the functionality of it, or right. So the location of it probably would go under the design patent, or it does go under the design patents. Okay, as Samsung will tell you.
What about the glass?
The glass, the glass is it. We have different types of antennas that are in there, all sorts of chips. What did we miss here? The touchscreen, all that type of stuff in there. Like the HTC, right? They have their speakers out in front, right, rather than in the back. Any copyrights?
Terms and conditions for using the phone.
I'm sorry?
Terms and conditions for using.
Terms and conditions, good. A manual that you would have ringtones. Okay. Now songs, and I know we just talked about the chime, right? So what's trademark versus copyright when we talk about sounds? There's a threshold to it. Okay, the length threshold and the use threshold, where it goes from being so actual songs and everything would be copyrighted instead of trademark. Okay. Trade secrets.
Operating system.
Not necessarily, because you can always reverse engineer it, right?
Yeah.
Right. The trick answer is we don't know, right? Because it's a secret. And then design patents, right? So we have the placement of the button and the speaker. We have color pattern, maybe the surface, you know, if it's really rough to the feel, the look and feel of the device, really.
So in all of those, where was the major battles between Samsung and Apple?
So they had their most of their battles were with the design patents, right? Because it was more like, hey, they copied our look and feel of it. The internals of the device, if you actually look at it, Apple, with the Snapdragon and the A8 processor and things like that, they license their internal parts from other companies. So the internal parts are not even Apple's. They're not proprietary in any, not proprietary to them. Okay, so it was essentially the look and feel of the device. If you remember, the whole market was going towards flip phones back then, right? Everybody was flipping up their phone and things like that. The candy bar was kind of dying, okay? And then Apple came out with the iPhone, and that kind of, that along with their touch and feel of it, you know, being able to play the games, the Angry Birds and things like that, that really changed everything around. But Samsung had their smartphones as well, and they really did copy, as the courts found, they really did copy the overall design of it, and they did so intentionally. So, yeah.
What about manufacturing processes for the surface finish? Is there
Right. So the process would be a utility patent, right? And that's absolutely patentable. In this case, I believe it is not. Most of the stuff is outsourced anyways to China, and not to say that you can't have, you know, patent protection in China, but that would be through the Chinese patent office. Okay, each patent would be only protected regionally, so wherever you file and are granted that patent. So in the United States would be for United States. It doesn't extend to, say, Europe, and then European patents don't extend to us.
Do you know if they have a patent on like the aluminum body?
Now, if they came up with, I don't know if they have off the top of my mind, I don't know if they have it for their for the material that they use. However, if they came up with a new composite material or something like that, that is something that is patentable. Yeah. Good. All right, so let's talk about trademarks. 3 ways to get trademark coverage. Common law, which means it's your branding, you just put a TM next to it, and that's it. You don't have to do anything with it, okay? All you have to do is just prove that that's your brand. State registration, you can register it with the state of Mississippi, and that covers you within Mississippi, right? And we're in central Mississippi, right?
Sort of northeast.
Sort of, okay, northeast, all right. Geography, failed me there. All
I
right,
thought Memphis
but
was close.
yeah, that's
Yeah.
yeah. I was going to Memphis, and then I'm like, yeah, Mississippi's close. But if you had, say, a coffee shop, and you were opening up different coffee shops all over the place, and some of them were in, say, Tennessee, right? Registering it here in the state of Mississippi would not cover you in Tennessee, okay? Then you'd pretty much end up with the common law protection. You could get it federally registered, and that's with the United States Patent and Trademark Office. That does require a little bit of work, but that will give you by far the most amount of rights. One of the things that you can tell is when you use this R right here, right, as opposed to the TM, the R means that it's a registered trademark, registered with the Patent and Trademark Office. And one of the big things that it does is it gives you the right to report the mark with customs. So you can give it to customs, and then if they notice like knockoffs or anything like big imports of that device, they can stop it, and it's pretty much dead on arrival before it gets disseminated anywhere. Okay, that's one of the bigger reasons to file with the patent office. Right there first.
Back to the previous slide, what is the advantage or point of the states doing registration?
Well, it would be the cost of it, and then also the scope of it, right? So when you're looking for federally registered trademarks, you would look at the federal database, right? So it would include everybody that's kind of applied for trademarks. But if you're looking just in the state, if there's no occurrence of that in the state, you're more than likely to get a trademark for that. You understand? It's just the scope of it.
Question on,
And then the cost as well. Yep, go for it.
I just have a question for the common law. I mean, you gave the example of coffee shop. So if you just think of open a coffee shop, have a name for it, and you just put the TM symbol behind it, that means nobody else can use it? Or how does that work?
It doesn't exactly work that way, but as long as you prove that you have an established brand, right, you can prevent other people from brand confusion, okay? So you just have a lot more to prove at that point, okay?
As far as like timing and everything. So
Yeah, as far as timing, but also the fact that, hey, you're the one who this brand actually belongs to, right? That, you know, you have to come up with, when you end up in court, it's a lot more to prove, right?
Yeah.
And enforce than if you've already had it registered, okay? When it's registered, you can send a cease and desist and all that fun type of legal paperwork, okay?
So if somebody has a federal registration of something that you're trying to use, you can't use it in the state.
That's true. Federal supersedes the state. Okay. Now, here's the federally registered trademark of Mississippi State. So whenever you register something, not only do you have to give it, give what your actual trademark is going to be, but then you'd also have to show a use in commerce. Okay. So in 2012, here's a sweatshirt of Mississippi State with that logo on it, and that along with the fee is what's minimally required to file for a trademark. Okay. Now,
can it be only
trademarks.
used in the website as well?
Yeah, absolutely. Yeah, if you only have like the logos, like for Amazon, right? For eBay, you know, they all have their logos and they're all you know, protected. So with the coffee shop, maybe if you have just a coffee shop in Mississippi, you know, you get away with common law or state registration. But if it's something where you're selling goods and you're doing it through the internet, well, you're not really just restricted to Mississippi, right? So you probably go for.
But it's going to be a little restricted to prove that that established and then used it from that timeline if you don't have historical data on it.
Right. Well, what you'd have to do is you'd have to establish your trademark, right? So essentially, you'd apply for it, and you'd show that you've been using it on this certain date. Okay, it could be today. All right, and then pretty much what happens is the trademark attorney will go and search through it, and if they find something similar, then they'll come back and ask you about it, right? Otherwise, you're pretty much just granted. That's what's called registration, and not really a grant of a trademark. Okay, as long as there's not a blatant violation of that brand, you're registered with that trademark. Okay. Some ways to lose your trademark, right? Dilution, right? Or lack of enforcement. All right. If I sneeze, you guys would hand me a Kleenex, right? Kleenex is actually is a brand. Okay, that's trademark. So they would prefer that you say facial tissue, right? Because that's what dilution is, right? Same thing with, I don't know, if you ordered a soda over here, you know what we used to do is we used to order a Coke, and then they're like, all right, then what do you want? And then I'll take a Fanta or whatever, you know. Or so, you know, there was actually a campaign maybe a decade or so ago, maybe even more before that. It was run by Pepsi but funded by Coca-Cola. Just think about how insane that is, right? You have a competitor funding the other person's campaign. And what it was pretty much directed towards was the fact that you have, you know, they were saying if you want a Pepsi, ask for it by name, right? It's all about brand recognition. And if the brand comes to, okay, if I need a copy of this made, how do I get that made? What do I do?
Xerox.
I Xerox it, right? And then Xerox will reply you tooth and nail. No, you gotta photocopy it. Xerox is our brand, okay? So when you get too big, sometimes your brand gets confused, right? When it just becomes a term of the art, okay? So you have to make sure that you protect that. And also, if somebody's blatantly using it and they've been using it for years and you just haven't been enforcing it, right? What happens is you can also lose your trademark that way, okay? We'll consider that abandoned.
Where does the laws of parity come into play here?
Laws of parity?
The parity law.
Explain a little bit more.
I was one day I was just looking and they said like you could start a brand as long as it's a parody of another one.
Parody of another one.
Parody?
Huh?
P-A-R-O-D-Y? Parody.
Oh, a parody. I'm sorry, I thought you were talking parody. You can, because there's no brand confusion. It has to be on its face, you know, something that's a parody of it, right? So if you're mocking something or you're showing something like that, it's pretty much brand confusion, right? So you'd have to make sure that, you know, it's like what Weird Al does, right? He has parodies of things, right? So you have to make sure that that it would be completely separate and never confused with the brand of the original company. Okay.
So if I digitize that image in a software program, monogram, slate in my shirt for myself, is that violation?
It is absolute violation. Yes.
But if I didn't sell it, but I just wore it,
It doesn't matter. It doesn't matter, because you're still using the branding of the university for your own benefit, right? so to look cool or whatever reasons you have for doing it. All right. All right. So copyrights. You don't actually have to do anything with copyrights. You get them automatically when they're fixed. When you fix a work, okay, for the first time, that's when you get your copyright. You can start using the C. For additional protection, what you can do is you can register it with the Library of Congress. Okay, not much required there. Okay, so out of all of these, probably trade secret might be easiest, and then copyright right after that.
Question on that one.
Yeah, sure.
Sometimes I see the copyright symbol with date next to it. Is that
Right.
necessary?
You always date your work, right? Just so that nobody else can say they came back before and did it, right? So that's kind of like a general rule that you always do, that you always date your work.
So
Okay.
that's to be the original date.
Because what happens is, if we go back to this slide, right? So if you look at the copyright, it lasts the life of the author plus 70, right? So well, I guess the date wouldn't be required there, right? Because we know when you die, right? And this one keeps getting extended. Does anybody know why?
Which
The copyrights? Yeah, but for who?
family
Yeah, of which one though? There's one famous company.
Disney?
Yeah, Disney. They want only one Mickey Mouse. All right. So trade secrets. All right. It can be anything. It can be a formula, pattern, compilation, program, device, or whatever, right? The funny thing about trade secrets is that there's no actual law that protects you. It comes from common law itself. There was a law up for consideration in last year, but it didn't pass. Okay. So all of the stuff comes from Uniform Trade Secrets Act, which was common law in like the 1870s, 1800, yeah. So the trade secrets, okay, it could be a customer list, right? Product formulations like COPE, search algorithms. But, okay, trade secrets are not generally known, but must be subject to reasonable efforts to preserve confidentiality. If you leave it on the table, right, that's your negligence. If somebody finds that, there's nothing you can do. But if somebody actually went and stole your trademark, right? So Plankton, he stole the Krabby Patty recipe, right? He wouldn't be able to benefit from it, all right? And any court proceedings usually would be sealed anyways to protect the trade secret. But probably the most dangerous, right? Because these are the common ways to lose your trade secret, right? If you leave it out on table, right? The owner gets drunk or something, right? And they start blabbing. Reverse engineering. Now, I guarantee you one thing. There's not many things that I can speak in absolutes about, but I guarantee you one thing, that if you're making any considerable amount of money, somebody else wants a piece of it, okay? So if you come up with an idea and you decide you want to keep it as a trade secret, well, guess what happens? Somebody's going to have their own set of engineers, and they're going to try to figure out how to reverse engineer, okay? Completely legal, completely legal. Independent development, somebody else just comes up with the same idea, okay? All those ways are ways to kind of render your trade secret just not usable, okay?
On the first bullet point, are there generally accepted procedures for that point?
Again, there is no actual law to it, so it all depends on the amount of negligence you had. So if you leave it on a table, they say, well, the secret wasn't worth keeping, right? If you have like guards surrounding a vault, or in Atlanta, that should be enough, right? I doubt that there's actually
So it's legally as ambiguous as it sounds.
Yes, absolutely.
So does the patent examiner or the trademark examiner know what the trade secret is?
No, absolutely not. There's no disclosure of it. In fact, if they disclose it, that counts as owner or owner authorized disclosure. Okay? So there's no registration or anything like that with a trade secret. You just keep your mouth shut.
So, in court, that's like something that actually gets enforced.
Right, and all of those would be,
so
they'd be sealed proceedings anyway, so usually what happens is you and a partner came up with an idea and you decided to keep it a trade secret. Now you guys get in some sort of tussle or disagreement, and he wants to form his own company, right? And now you deal with the trade secret, like, well, you know, he also knows what you know. Is he allowed to tell? Or if you have a disgruntled employee, are they allowed to disclose, you know, the secrets that you guys have? So that's usually where we see these things, okay? Because you know what, if somebody posts something on Google, right? I mean, once enough people saw it, that's it. I mean, the secret is out of the bag. And even if it was illegal disclosure, you may have some legal recourse, you know, to maybe like in a civil suit or something. But you know, that's it for your company, right? You no longer have that secret. Right? Then you're pretty much relying just on your brand to get by. Right? Good.
And there's value in trade secrets in that there's no limited period of time.
Absolutely.
It's not 17 years, it's not 20 years, it's not
And it's
whether or
the
not
life
you
of the
pay your
offer plus
registration.
interest.
It's as long as you keep it.
As long as you keep it a secret. So if you look at Coca-Cola, right? I mean, they made a great gamble, right? Because they've been around for a very long time, and they're very successful. And had they filed for supposed patent, right?
They've been gone
That's
20 years.
20 years. That's it. That's all the coverage they get. Then anybody else can use it. Okay. Same thing with Google, right? That's the search algorithm. They could have very well patented it, right? It's a process. But what happened? They kept it a secret, and they've been, you know, they've been around for more than 20 years as well. So absolutely, there's a great deal of value on that. All right. You have to know what you're doing. All right.
So why can you not prosecute somebody who reverse engineers?
Because it's completely legal. You have no actual protections as far as.
Oh, because they don't know, you don't know.
Right. Well, that's absolutely one case. But even if they use your device to, you know, to reverse engineer it, right? You don't have any right to exclude. If you file for a patent, you have a right to exclude others from making it. If you didn't file for a patent and you're keeping it a trade secret, you do not have the right to exclude somebody else from making that same thing. You're relying on the fact that they're not going to figure it out, right? So with the, like if you're looking at formulas, right? If you have a very complicated formula, just because you have the answer doesn't mean you can come back to, you know, the different variables in the equation, right? So for example, take like logarithmic equations, right? Easy to calculate one way, almost impossible to go back, right? It's the same concept. And that's what like a lot of the cryptography algorithms are based on, yeah?
I guess like what protection do you have though? Because if somebody reverse engineers it, you lose it. And if somebody steals it and illegally discloses it, you lose it. So like.
Right, but for if somebody illegally discloses it, right? So that's not an owner or owner authorized disclosure, right?
Right.
So there are steps that you can do to kind of protect yourself for that, right? Yeah, exactly.
Okay.
So
Many of the more well-known cases are, for example, an executive being recruited to a different company.
Exactly.
The other company doesn't want to disclose a trade secret. They want to use it, right?
Okay.
And so it remains.
right.
So I guess that's a good case would be like internal.
Yeah.
Right. And usually when you would get hired there, if you're going to be exposed to that trade secret, like the janitor wouldn't be exposed to the trade secret. I would argue maybe that might be the first step. You know, if you're telling the janitor your trade secret, that'd be a failure to adequately protect it, right? But if it's somebody that you're bringing in higher up, you make them sign a non-disclosure agreement, right? So let's see. Okay, patents. My life for the last dozen years or so. So what it does is it gives you a right to exclude others from making, using, or offering for sale or importing the claimed invention. There are strict time limits to apply for a patent. If you wait too long, you may actually not get a patent. It is probably one of the most common ways of seeking protection for your idea. Again, it's territorial. There is no worldwide patent. There is something called the PCT that you may be familiar with or maybe not. That's the Patent Cooperation Treaty. That only serves as a clock stopper, okay, and a launching ground for you to apply in one of the member nations. It does not give you any protection in any of the member countries, okay? So if you want protection in Japan and in China and in Europe, you have to file with those offices individually, okay? So the patent round, the life cycle of patents, right? So what happens is you come up with an invention, and then you want to seek to protect it, okay? So you file for a patent application, and what we do is we publish the patent application once you get it granted, right? And other people can understand it. And then what happens is they start realizing that there's some issues with it once the whole framework and the the industry builds around it. They start to find out that there's some issues with it, and then they correct those issues and they file for protection of those issues. So for voice over IP, right? What we'll do is let's go into voice over IP. That's the initial protection. We go around the whole thing, then people, everybody starts, commercializing it. You got Skype, you got Vonage, you got all those. People start using it in their house, right? Magic Jam. Now we have an issue, right? What's one of the bigger issues that we had was if I call from a landline or even my cell phone, right? And I'm calling 911, what happens? They know exactly where I am, all right? They can triangulate my location, or there's location information that's given to them, okay? For voice over IP, because everything's traveling over the internet, you don't have that that capability, right? So there was a requirement for that future investment, right? How do we fix this problem? Okay, so came up with E911. It's a way of reporting the location for all of all voice over IP calls. Okay, and then we go through the life cycle of patent again. So there are initial patents, but most of the patents that you talk about are those that are building on an existing technology. All right. Does anybody know who this is? I brought the beard for both of us, so that's Abe Lincoln, okay? And this is the deal that we have. That you tell us how you did, what you did, and if you're granted a patent application, we'll give you a time-limited monopoly. So that's 20 years from filing for a utility, or 20 years from grant, or for a utility patent, or 14 years from filing for a design patent, which will be soon in May. It'll be 15 years. Okay. So the reason why Abe Lincoln is up there is because, anybody know? He is the only.
Probably rated the patent office or something.
No, he didn't actually. He was the only sitting president to actually have a patent. So yeah, and it was for like boats, helping boats go through canals and things like that. There was like inflation things at the bottom. All right. So why should you get a patent, right? The main things are it helps you gain entry into a market, and it excludes others from making it. Okay, you protect yourself that other people can't steal your idea. It's your idea, you should be able to use it, right? But some of the other ways of looking at it is that you could use it as a marketing tool when you go to somebody to sell, right? Sell your product. You could say, well, we have a patent, nobody else can do it the way we do it. Or, have you guys been awake, like have some insomnia late at night, you're up and you're watching one of those infomercials, right? And what happens? Oh, this invention's so great, we got a patent on it, patent pending, all that stuff on it, right? So it's absolutely used as a marketing tool. And then the other thing is, just like your house or your car, you can sell it or you can license it, okay? And this is a huge, huge industry. Even with expired patents, they still sell, okay? Very big, okay? If you can get your applications to sell, typically that means somebody wants your invention, right?
What's the incentive for buying an expired patent?
I don't know. But it has happened with like the Motorola patents. They were bought for, I think, like, I don't want to get the number wrong. Was it 1.9 billion or something like that? It's insane the amount of money that goes into these things. But I think it has to deal with the just sometimes you need the number of patent applications there. They want like IBM to chase numbers a lot of the times, so they want their numbers out there, that you have this many patent applications and things like that. And then a lot of times it's because they serve as a basis for other applications. But yeah, I rarely understood that myself. One of the other things, especially in the research environment, is that it allows you to ask for funding for your project, right? That look, this is we're the only ones that can do it this way. We're the pioneers in this field. So guess what? You know, you want the experts? Come to us. Okay, so you can really, as far as research goes, you can do that. And then, you know, all the stories of Facebook and even Google and all that stuff. Most of the innovations, most of the ideas that you have at this age, most of them probably are not going to go anywhere, but there are a couple that will go a far way and make you a billionaire, right? Patents, what do they look like? This is the front page of a patent, all right? Do we recognize any of these? Are they still here, maybe? All right, this was granted to Mississippi State University, all right? And this is essentially, this was a genius way of figuring this out. They wanted to see in a concrete structure the flaws, okay? So what did they do? They throw like a chain or something and they make noises, okay? And then they know what the flaw would sound like, okay? So they eliminate all the noise and they just look out for the for that flawed noise. And if they notice that, then they know that there's a flaw within this concrete structure. Okay. There's another one, right? I got a kick out of this one though. You can tell the size of the animal by kind of just measuring the antlers and stuff. So, and this can be taken from pictures. All right, so what exactly is patentable? Okay, we have a process, machine, improvements thereof, methods for making manufactures, and anything that's non-obvious over them, and improvements thereof. Okay, a process is a step of things. Okay, so we were talking about the Coca-Cola bottle. So how, you know, every step that you take in doing something, right? That would be a process. Okay, here's a good example. For process, does anybody have the new iPhone here? Yep. You have Touch ID on it, right? Does anybody know, you guys know how Touch ID works, right? It authenticates you into the device. It's a biometric scanner, essentially, right? So it senses your fingerprint, and it lets you get into the device. Biometric scanners, fingerprint readers, I mean, if you've seen, you know, a TV show 15 years ago, you know that that stuff existed, right? I have one on my laptop, right? But the one that I have on my laptop, what it does is you have to scan your finger up and down on it, right? And then it kind of takes your fingerprint. So the fact that you're authenticating somebody through a fingerprint may not be patentable, right? But the process in which you do it could be patentable. So instead of swiping your finger up and down, you leaving your finger over there and it recognizing your fingerprint and unlocking the device for you, okay? So that would be a process. Machine, it could be the entire phone, or as you know, it could be, and usually is, parts of the machine, okay? And it can be a combination of devices as well. So if we're talking about neural networks or something like that, you're talking about different types of different types of devices and how they communicate with one another. That's also patentable. Manufacture, produced items, physical articles, plants even. This is where the plants would go. Composition of matter. This is usually like medicines and things like that. Okay, but it can be other things as well, like the actual material your device would be made out of. Yes, sir.
And a question on this: say you do create some new material, like what all does that protect you against? I mean, say you have some material and somebody adds in a tiny amount of something else. It doesn't change the material really, but they can claim it's different.
So that would pretty much go to, oops. So it has to be new, useful, and non-obvious, right? So anything that's non-obvious, you're protected against automatically, okay? So if you came up with a car, right? And it's a green car or whatever, and then somebody came and all the data was changed the color of the car, right? That would now be an obvious variation of your invention. So you're automatically protected from that. Okay, somebody cannot get a patent on that, and they cannot exclude you from that. So whatever improvement it is, like E911, it has to be something that is significant and something that's non-obvious. Okay? All right. Even you yourself, take back what I was about to say. So, and then the last category is the improvements on all the other 4 categories that we talked about. Okay, that's all I have. Any questions you guys have?
Would you be willing to share this presentation?
Sure, absolutely. I think I'd send it to you, but I can send it again if you like.
So you're right in the hotbed of what has got been a huge workload for the USPTO.
Yep.
And tell us a little bit about how you survived that. And,
we call it job security.
And a little bit about the day in the life of a patent examiner.
Oh, absolutely, absolutely. So essentially what happens is that the typical examiner is kind of insulated from all of this stuff already. The higher-ups kind of make more of those judgments as far as the applications that are coming in, protecting against influxes, and then just like not overhiring people just to take care of a temporary influx in a technological boom, right? And then seeing what technologies are dying and which ones are like upcoming, and making sure that there's examiners to handle that. What we typically want are not necessarily well-rounded examiners, but examiners that also specialize in a specific field, so they become the experts of that, know the ins and outs of it. We had a huge backlog. In my area, it was like 4 years, but we've cut that down significantly. Our goal is that's 4 years, not until you get your patent. It's 4 years until we even open it up and look at it. Okay. And then after that, you go through that whole process of getting a patent. So, we've done a lot of groundwork on that. Our goal is 10 months. Okay. Some areas are added. We're close to it. We went from 4 years to about like 18 months, 16 months. There are other areas that are still kind of 2 years or more far. So, it's typical examiner doesn't notice it though. They notice it when you're running out of applications, because then they don't have any work to do, and then they're asked to help out with other similarly related applications, right? For example, if I'm in multiplexing, networking so close to that, right? With networking security, right? So if you're looking at IP, right? The actual protocol, internet protocol, right? So TCP/IP, that would be in networking, right? But if you're looking at IPsec, right? That's security stuff. We have a whole different department for that, for security and cryptography. But those people that are dealing with IPsec can deal with IP, because they have to know IP just to deal with IPsec applications. So there's a lot of like backends and things like that that are built in to protect against low filing. The high filing is something that we can deal with. Yeah, it's the low filings that sometimes give us some issues.
We got another class.
Yeah, we have another class coming in.
So if you file a patent, like say you were 2 days or something, got rejected, can you refile them?
So you get two bites at the same apple, right? So without going into too much, but yeah, usually the first time you do get rejected, and then you get a chance to come back and change it to overcome the evidence that was provided to you by the examiner. All right, cool. Thank you guys.
Let's thank Mark.